You, on behalf of Splice, filed a false DMCA copyright takedown notice. This was the first time my channel was kind of put at risk. Copyright strike on my YouTube channel. And they told me to stop talking about them, right? Am I gonna do that? No. So this is the CEO of Splice. Hi, Krystle. The number of companies who have threatened me personally because of the videos that I do on this channel is continuing to increase. The last time it was TuneCore, and they were threatening to take legal action against me because I was talking about not only their terms of service, but I was talking about a specific situation for a client that I represent and just everything that was kind of happening. And we've had some things going on with Splice. If you are new here and you're not aware of the backstory, I'm going to just briefly go through it. And it's really important to me. If you guys will just do me a favor and make sure you watch this until the end, because there's a lot of things that I want to cover, but it's very important that you know basically where we're at today. All right. It's been a very emotional week. It's interesting being on this side of things because the purpose of me doing the original video, which was actually July 8th, I did my terms of service review, right, for Splice. And if you don't know, Splice is a company that provides you as a music producer, as a creator, the ability to download sounds and loops and just to enhance your creativity. And in fact, my music producer and I have used their service for a long time. And it's funny because what kind of like started this entire thing was I just briefly on a live stream had mentioned someone asked a question about being able to use these samples from Splice in the music. And I just quickly in passing, I was like, yeah, it's been a really long time since I looked at their terms of service. One of my clients who's a music producer had me look at them like 5+ years ago at this point. It's been a really long time. And I go, at the time that I looked at it, I just go, for me, it wasn't abundantly clear about just the ability to like use the samples without restriction at all. And I just go, just based on that, that's what I told the client. So I mentioned this on the live stream. And there was another YouTuber who, kind of left a message, was like, hey, I don't think this is right. And kind of called me out. And fair enough. I just go, you know what? I made that comment real quick in passing. So I went and took like a really quick look at their terms of service. And then on my next show, I was like, I said this thing. From what I see again, I looked at it again. It looks, like you're good to go. So I just kind of made that update. But I put it on my list that I wanted to actually go through and substantively and very carefully go through the terms of service for you guys, because that's what I do on this channel. And so I do these, terms of service and, exposed videos because I'm exposing what these contracts say, because they're like 20 pages long, 30 pages long. And a whole lot of us, when we sign up to be on these platforms, we accept the terms of use, which is the contract that we have to sign in order to use the platform. It's not negotiable. Just out of curiosity, I've been going through these different platforms to just see what they say and let you guys know. Splice was just on the list because of all this. And I was like, all right, so today's the day, July 8th. So I post this video on their terms of service, and the following day, which was the 9th, I get a cease and desist email from Splice. They were basically just being like, you're misinforming your audience, you're causing confusion to our customer base, and also like, we really hate your clickbait Splice exposed title, a bunch of things that they were just really unhappy about. In that original email, they had said, we'd hate, and this is a quote, okay, so it goes, we would hate to have to issue a takedown due to these inaccuracies. So, this came from their legal department. I was like, kind of sounds like you're going to file a copyright takedown notice because you're unhappy with what I said about you. That's not how that works. You're not allowed to do that. But anyway, it was just in the email, okay? There was a very long email. And, basically in their original communication, they just said, look, like the two big things that we have an issue with is, number one, you mentioned at the beginning of the video that the date of the terms of service for like these companies that you review or whatever is usually like they update it. And if you're like, oh, there was a real recent update, it must have been because there's like a lawsuit or a claim or something, or something going on. I totally said that. And if you look at my other videos, that's usually how I always start these. And I just make a note. And I kind of, for example, in my TuneCore terms of service video, I'm like, we sent our big demand letter about how unlawful we thought their terms of service were on December 1st, and then their terms of service were updated on the 10th. And I'm like, maybe it's just a wild coincidence. But anyway, so, they were just like, we don't want you to give the perception that we're like being sued, because we're not. I was like, okay, good. I don't know how I would have known otherwise. That's not what I said, but I definitely don't want to cause any confusion. So I'm like, all right, cool. In the back of my mind, I'm like, I'm going to update that. I'm going to make sure that that's clear. to the audience. No lawsuit, that's what they said. And then the second thing had to do with transferability. And if you guys watch that terms of service, you'll see, and I'll show you, as part of this video. And just to be like, I took a little bit of an issue because I'm like, their language is, pretty clear as far as having the right to commercially use a sound that you download as a subscriber in your new song, right? So to use it commercially and to sub-license and to get it remixed and to sync to TV and film and games and all this stuff. And so I go, that's absolutely what it says. But I took issue with a couple of times where they go, these rights are non-transferable. Because I go, I'm thinking all the way down the line for my music creators, because I represent you guys when you go to actually sell your music. So selling your music outright. So John sells to Susan. And when John sells, and I'm representing John, we have to make sure that there's clearance on anything that John doesn't actually own, right? So like a sample. And so looking at their terms, there's this certified license. And I was looking within the contract and we're reading together and they're like, they give you this certified license, which, proves you're okay to use the sound and all this stuff. So basically what they had said is they go, well, you're basically saying this thing about, a question mark on the transferability. We have a problem with that. And in the email, and I just mentioned this, and I'm going to make sure I say exactly what Splice told me because it's very important that I share what they said. And part of this copyright strike that they then filed, which we'll get to, what they mentioned in the copyright strike is that I had shown this email in my follow-up video that I did. And the reason why I actually showed the email is because I'm allowed to. And they're like, this is a, impermissible sharing of a confidential communication and blah, 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 blah. And that's not how this works. And I'll explain why. But in any case, I showed it because I don't want to put words in someone else's mouth. You know what I mean? I want to make sure that when they're like, hey, this is the thing we want you to clarify, I was literally quoting them. So that's why I did it. It wasn't meant to be like, aha, showing everybody. So I'm not showing it on this video, okay? But I will say that in that email, specifically it was said, a transfer of rights is okay by transferring, the and sub-licensing specifically. So they go, there's a distinction here. Sub-licensing is okay by us, but what we're not okay is that you can actually transfer the rights of the certified license that the subscriber obtained to another person who may be a non-subscriber of Splice. That is not permitted. Their words. That is not permitted. So like even in this email where they're like telling me to cease and desist, I'm causing confusion, all this stuff. Well, if you sell your song and you're not just licensing it, you are actually transferring, and you have to transfer, right? John has to give, who was it, Susan? If Susan's the new owner of the song, there has to be a way to actually like transfer the right to the sample, right, in the song. So that was kind of the point that I'm making, okay? And I just go like in the contract itself, that's all I'm saying, whatever. So cease and desist. Without showing their email, what I will show is, my responses, okay? So in response on, and this would have been the next day. So now we're at, I think it's the 9th. So here we go. Make this a little bigger for you guys. Okay, so I respond and I go, hello, Splice Legal. I find your below email very refreshing and very much appreciate that you reached out to clarify these items. Would you by chance have a few minutes early tomorrow to jump on a call? Because this was actually right before my show. And I go, to clarify the non-transferability issue, because I go like, this really still is not clear. And also, could you send me a sample of your certified license that users receive? And then here's the time, let's coordinate, yada, yada. To their credit, they took my invitation and we scheduled this call. And so that way I would get the updates. And then my intention was to provide the update on the live stream 2 hours later. So, we get on the call, it's all very friendly. And, I kind of went through and I pulled up the terms. I'm like, so look, I understand we're all lawyers here and we have like a difference of opinion and our interpretation, stuff like this. But I go, I might be an idiot. I've been doing this for a long time. Let's pretend I'm an idiot. If I am misunderstanding, there's a potential that someone else will misunderstand or misapply what this says. And so we just want to avoid confusion. And, to Splice's credit, they come back and they're like, when we update our terms, and this is, back to the original point of we update our terms to reflect when we have new services and, functionality and whatever, just because we want transparency and clarity. And I'm like, that's so great. And we're like high-fiving, not really, but you know what I'm saying? Like, it was just really positive. And so then on the live stream, which was on the 10th, right? And I get up and I give you guys the full rundown. And I don't BS because I'm not going to pull back the punches. Like when you send me kind of a rude cease and desist, which it kind of was, but nonetheless, I go, this is kind of what they say. This is what they said on the phone call. My job is to let you guys know the biggest piece here is that they are telling me to tell you that they're okay with you basically using the sample within your song for whatever you need. The idea is to enable you to be wonderful creators and to go out to the world and make money from your music. And so I shared that. But I also didn't pull any punches because that's not what I do. Sorry. I think obviously that upset someone. Become your own record label, which is literally if you're like, hey, I want to start a record label. Cool, I got you. Understand the entire music business. I want to set up my LLC. I want to do the marketing. It's a lot. So for example, sync licensing, for example, music marketing, it's significantly cheaper than anything you would ever get from a law firm as far as all the stuff that comes with it. And you want to make 6 figures from your music career and you want to do this for real. Like I'm going to give you what you need. So here comes July 11th. It's the next day. And, I get it. And this is kind of what I covered on the last video. And, I get notice there was a DMCA copyright strike on my YouTube channel in regards to that video. And, obviously that's a little stressful. And I kind of went through this right in the last update video. And I'm like, I've invested quite frankly, hundreds of thousands of dollars of my time over many, many of years, in this channel. And I have like 1,300 videos of education. I'm trying to help you guys and all this stuff. And I go, but setting that aside, obviously I'm just really concerned about the channel getting deleted because from what I can see, they filed this because they don't like what I said. And then I took you guys through it and I showed you the actual claim and the email that came from YouTube and what they said. And Splice was like, the content and the reason why that they're filing this is not applicable. And then they went through 2 things, and one had to do with they're like, I'm showing a private communication, confidential communication, which I explained to you guys. I'm like, I'm a litigation attorney. And the way it works is that you can identify communications as confidential when you are in litigation, which is not the case here. And you can identify them for purposes of not, being like, hey, I kind of want to settle. I'm not admitting anything, but like, maybe I did run over your cat. Oops. So someone can't then use that to prove your liability that you ran over the cat. So that's how it works. And so you can't just use that and be like, I didn't want you to share my email. That's really what they said. They just didn't want me to share the email, but I'm allowed to. And also I went so far as to actually like redact names and whatever. But the bigger issue that I pointed out is I go, this isn't copyright infringement. You don't get to use the DMCA copyright takedown function through YouTube because you're not happy about what someone is saying in their video. And then the second thing that they had cited to was the fact that I showed their certified license. Now, what I pointed out in the last video was that what they actually said, even though they mentioned the, private conversation, what they said, the reason and what they pointed to with the actual time code, because you have to tell YouTube, you go from this time code to this time code. This is the thing that I have copyright protection in. And what they pointed to was actually just the certified license. And so what I had showed you guys in the last live stream, I just showed you where to get this in your account. I was like, as a music producer, as an artist, for you to protect yourself in case you get a claim from Spotify or your music distributor or whatever, saying that you stole a sample, because stuff like that happens. There's content ID issues, right? That Splice made a point to be like, hey, certified license, we've produced this for you. You get it in your account or whatever. So I showed it for purposes of helping them to help you to really help yourself. And so my producer had just generated one of these, and I showed it on the screen for 54 seconds technically. So they filed the same. They said for 57 seconds, this is the copyrighted thing. So they were claiming that I infringed their certified license and the copyright contained there too. So anyway, I went through the full diatribe of like, my video was educational, which it was. And to the extent that they do have copyright in that document, it was okay for me to show it. So here's the thing. And this is the update that for those of you who are following along, you didn't get to see or about. But I will say real quick, like PS, as you know, I'm an independent artist and whatever. And I was supposed to be working on my album. So I was like, this is so ironic that on that day, after my entire workday, because I don't get to stop to deal with my stuff, I am representing big clients, big deals, all this stuff. So I'm running my law firm, and then the time that I had scheduled to work on my actual album and do all my stuff, now I'm dealing with this. So I was just like, this is fight your rights, right? But in any case, so that same day, what I did was twofold. One, I took the time to go through this so I could provide an update video, because really the only other option that I had was to be silenced. Because what they told me in that initial cease and desist was that they had threatened me, that they were going to file this, and they told me to stop talking about them, right? And so I go, am I going to do that? No, because I sit here on this channel and I tell you guys, fight for your rights, protect yourself. And so I wasn't going to do that. So on that same day, I did twofold things, which is one, I put together a video, I recorded it, I laid out, what I could and did all the things. And, something that kind of came out is that in regards to this certified license, it got addressed. And it's a very interesting piece of this. But in any case, the second piece of it was just the email. And I go, before I file my counter notification through YouTube, I'm just going to send the legal counsel who we've been chatting with. They didn't talk to me about this. They just filed the strike. And so I sent an email to them and I go, in fact, let me just show you. Because again, I'm showing my communications and I'm just not going to show theirs, right? We don't want any more problems with Splice. All right, so I sent this email, right? So we're on the 11th and I said, notice of violation of section 512F of the Copyright Act. So I, addressed this to the actual person who filed it on behalf of the company. But I go, you, on behalf of Splice, filed a false DMCA copyright takedown notice related to my educational video. My educational video is protected by fair use under the Copyright Act pursuant to these different sections. You state in your copyright claim, which resulted in a strike on our channel, that, you're like, confidential stuff is this confidential correspondence and this proprietary document of the Splice license. And so I just go through and I lay it out. Okay. And I'm trying to be as factual as possible because it's just not helpful to kind of hit under the belt, so to speak. So I go, I gave them the case. I cited to it. I actually attached this case to my email with highlights. And I'm like, I just want to break this down. I think you guys are really good lawyers over there. But just in case you just don't understand how this works, here's how it works. But anyway, so I got on the email and I'm like, Splice's claim for the license as it appears, it's not copyright infringement. And I'm like, quite frankly, if you're mad about what I said, and you're like, it's defamation. Okay, you have a claim for defamation. So I'm like, in the little vacuum of copyright infringements, we have to stay in there. So this is what I'm talking about. And I just go, this isn't copyright infringement. So I go, respectfully, I'm giving you until tomorrow to voluntarily retract your false DMCA copyright strike. You can do all kinds of other stuff against me if you want, but this is not something you're allowed to do. Okay, so I'm just giving you an opportunity. Please just retract it. And later on that night, I did in fact get a response from Splice. And once again, I won't show you the email because they don't want me to. I think it would be helpful to give them a chance to have their position stated and all that, but I won't do it. It's fine. But I will share generally what they said. So they just went on to be like, that's, we sent you this official legal correspondence. So they doubled down on the whole, you weren't allowed to share our email. No, that's not how that works. So on the certified license, I thought that they made, an actually really good argument in response. And this is what they said. And I should say it would have been a really good argument, which is our certified license is a proprietary document. We don't want anybody to basically see what you showed on your video and go and rip it off and make a fakery one and basically cause harm to our users. And I'm like, that would have been a really, really good argument. Again, it still is not copyright infringement, but as far as just being like, hey, we don't want you to show it, we need you to cut this out or whatever, it would have gone to that. However, a couple of things. One, if you just do a search on YouTube for people who are just like, hey, this is my account, this is a certified license, and just lots and lots and lots of people. But beyond that, and the fact that this seems to not actually be a big deal for Splice because they don't take any action against these videos who have, that have actually been up for years and years and years. The most important one, the most important channel that shows this certified license is Splice's YouTube channel. And they in fact have a video where they show a certified license and kind of explain how it works and all of that. So I'm just like, you know what? Now it just sounds like this was very personal against me. It sounds like you didn't like the fact that I was just very straight with my audience about what happened and what was said and whatever. And you use this as an opportunity to get my video taken down. Just my perception. And then they raised other arguments and they're like, you used our trademark without authorization. And just so you guys know, under the law, there's a nominative use, which would allow someone, and you'll see this sometimes, we were watching Dexter the other day. Yes, I'm watching it again. Come on, it came on Netflix. And, there's this scene where there's Cheerios on top of the fridge, and you very clearly see Cheerios multiple times, and then someone's eating it. And you can be like, well, they might have a deal with Cheerios for the permitted use, but pursuant to the law, you can have trademarks incidentally used where needed to reasonably identify who you're talking about. If I'm like, hey, Pepsi, and I'm doing a review on Pepsi of some kind, and I use the name Pepsi, and I even use their logo, whatever version of their trademark that I'm using under the law, I am okay to do that because I can't identify Pepsi without using the name Pepsi. So, okay, to that extent, another argument, but it doesn't, quantify as copyright infringement. And then to the whole like devastating impact of showing the certified license, it's just going down. And then also just like as a lawyer, you should know better. Just stuff like that. You know what I'm saying? Like, all right. So I'm just, reading through. And then once again, it was a you better immediately cease and desist, discussing Splice, and to take down your terms of service video, to basically just take everything down. So once again, this doesn't really feel like a copyright infringement issue. It's you have a whole lot of other claims potentially. And so they gave me 10 days, or they're gonna, enforce against me and all that good stuff. So fast forward to July 15th. So 2 days ago, I got an email from the CEO of Splice. And I'm also going to show this because there's been a little bit of press, and at least the publication that I read this morning quoted this email, so it led me to believe that it was actually given to the press. I don't know that to be the case, so don't take my word for it, but it actually quoted this. So that's the only reason why I'm actually going to show it to you. All right, so again, direct emails and stuff taken out. But anyway, so this is the CEO of Splice. Hi, Krystle. Splice is a creator-centric operation. It's one of our core values. We take our terms of use seriously, and it's our priority to protect our customers as well as our community of sample creators. We regularly update our terms of use in line with feature updates as well as feedback from Splice users and our partners. And that's fair. That's, again, just reiterating what Splice told me, which is we update our terms of use all the time because we want to make sure that everything is fairly represented as far as the products that we have offered and stuff like that. So he's reiterating that sentiment. That's fine. And to specifically address one of your key points, yes, you can access a license, so their certified license, to a Splice sample even when you no longer have a subscription. That was one of the things that I kind of pointed out. And I go on this call with their legal department, I had listed out the stuff where there was inconsistencies, including from what they shared with me. Because I was like, on the call, they were just sharing, yeah, we have our copyright at, splice.com email, and we are constantly working with people. And if you need to get a copy of your license, even if you're not with us anymore, we got you. And I go, oh, wow, that's like great to know. And I'm like, I'm going to tell my followers. And then I told you guys. But I go, the reason why that matters is because that's not what your terms say, right? So as far as like having access to your account and what do they call it? The stacks, on the samples and all the stuff. And I go, just for clarification, let's just address this because there's like conflicting terms happening. And then even on the call, the attorneys were conflicting with each other on what the current status is. So anyway, this is what the CEO is saying. So he goes, you can access a license even when you no longer have a subscription. Great. We fundamentally support the rights of creators to express themselves, even if we disagree. So I'm assuming this is in relation to me. Even when we disagree, and with this in mind, we'll work with YouTube to remove the copyright strike. I hope we can both continue to responsibly inform our creative community. And I waited to respond to this until this morning because the copyright claim and strike was not released until last night. But it was, to be fair, it was, which is great. And I'm very glad that that happened. Do I wish that maybe there was something else in this email? Do I wish that perhaps something else had been addressed or said in this email? Yes. So I did respond, and basically this is what I said. I go, hello, Mr. CEO. I go, I was very surprised to get the copyright strike for sure. But I go, at the end of the day, we were just asking that the terms of service be updated because there's some conflicting language. And I do want to go back to that because that's still our big call to action. This became a whole thing about like me and this channel, but more importantly is you guys and making sure that you have an agreement that you're signing that fairly reflects what's actually happening. So I want to go back to this. All right. So it's going to be kind of our call to action because I think, after our call last week, Splice had said they were going to update their terms of service. And I'm like, if you guys do that, that'd be amazing. And it really will prove your point that you really care about your creators and you are concerned about transparency and all this stuff. So I really hope that they still do it. If they do it, I will definitely talk about it. But I do want to show you guys just a couple things. Before I get to that, I do want to just say like a thank you because, this was the first time my channel was kind of put at risk because of something. Like if someone's, threatening me, that's one thing. But when you like quite literally put my channel at risk, that's a different thing. And you guys are just so nice. And I don't expect anything. I don't, you know what I'm saying? That's not what I'm here for, but it really meant a lot. And your guys' comments and your support, like it really, really meant a lot. And I even had some other creators coming out, like Ben Jordan said something, which, you know, it was very nice. So I just wanted to mention that. But anyway, so let's just go back. So as far as what I would really like to have happen here with these terms of service, here's the now infamous language. So a couple of things, just in regards to the ability to use your new recording. This is kind of what I said to Splice's legal department. I go, the right of like using the account and all the rights that you get and stuff like that, not being transferable is okay. We understand that. And it says you have the perpetual right to use the sound within your song. And you can't use the sound all by itself. And that's what this whole language thing is that we went through, right? And you're okay to then sublicense, distribute, transmit, communicate. And so what I offered to them, I go, could you just revise this to say, this means that you may modify, reproduce, sell. That word is not in here. Sell, publicly perform, distribute, transmit, communicate to the public, sublicense, otherwise use the sounds in your music recording. And I'm like, just change that and be like, specifically related to your new recording containing the sound subject to the prohibited uses in this. And I just go, because then it also later on in the agreement, right? There's this, it goes the assignment, the agreement, your rights, the obligations may not be assigned, contracted, delegated, or otherwise transferred by you. And I go, if your kind of intention here is just to make sure that Jane does not have, she can't just go into the account and be like, oh, great, there's like 1,600 samples. I'm just going to go ahead and get all of these from John. That's not what we're talking about. What I communicated to them, and I go in like, a real life situation, when I sell millions of dollars of music catalog and I am looking at these contracts, I go, I just don't want you to have your users running into a problem because we think they're actual rock stars and they're going to make money and we want to set them up for success. And going back to the cease and desist email where it said the sublicense is not a transfer, but a transfer of rights is transferring the certified license that the subscriber obtained to another person that is not a subscriber of Splice. That is not permitted. That's what you guys said. Okay, so you can understand why perhaps this is not quite as clear as it could be. So let's just go ahead and clear that up because I think that's what you guys want to do. So that's where we're at with this, okay? I guess where I would just like to leave this is I definitely would like your guys' feedback. At no point have I, asked or wanted you to boycott Splice. My a little bit of a concern is just that maybe someone's feelings got hurt who had drafted this, who was a part of this legal team. And this was also the same person on behalf of Splice who filed, the DMCA takedown. And I don't know if that was a component of it. But nonetheless, they are saying that for these certified licenses, that you can reach out anytime, you can get them anytime. But I'm just like, look, if John and Jane, I don't know if they're the original people we started with, or Sandra. So John gets the certified license, makes the song, puts the sample in it, and then he goes and sells the song outright. If they're saying that you cannot transfer the certified license as part of that sale, and that's not what they're saying, what they told me anyways, they're like, no, like, we work with major labels all the time, and we're doing every variation of deals, and these certified licenses are great. That's what we're focusing on. Make sure you get your certified samples. Keep track of them, please save them. And then I suppose in Splice's own words to me, if you do run into a problem, you can reach out to Splice and they would be happy to help you.